my faith arising. I'm crawling out the trenches, holding me.
Hello visionaries, welcome back to my channel. My name is Maresa Talbert. I'm the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I've interrupted my regularly scheduled content for this week because I've been seeing social media posts about the trademark battle among 3 skincare and cosmetics brands. One is Skin by Harvey, the other is Skin Plus by Beauty Concepts LLC, and the other is Skin by Kim Kardashian. So as a trademark attorney, I wanted to get in on the action. Under trademark law, the general standard for proving trademark infringement is a likelihood of confusion, which merely suggests that the general public and/or the consumers of each brand might confuse the brands or erroneously think that the brands are somehow related to each other or are affiliated. So in this video, I wanted to offer a brief analysis on these trademark applications and discuss whether there is a likelihood of confusion between Skin, and Skin Plus. Now, all of these marks are clearly based on a derivative of the word skin, and they are all associated with some type of skincare product, service, or cosmetics. And none of them have yet to receive their trademark registration. So let's break this down. So first, let's talk about a word mark versus a design mark. When you're filing for a trademark registration, it must be determined in the application whether you're applying for a word mark or a design mark. A word mark is just what it sounds like. It is a trademark that is simply letters, with no regard to style, font, color, or size. When you apply for a word mark, it means that you can vary the design of your trademark in use without causing a conflict with your trademark application. So that means you can change the letters from uppercase to lowercase, you can change the font sizes, you can change the colors, you can change the font types. You can generally change the style of the trademark as long as you don't change the letters of the trademark. Alternatively, there's the design mark, and the design mark can include both graphics and words. A design mark is what is chosen when a trademark has a logo or other type of graphic, any colors that want to be preserved, or any specific styling or font choices that you want to ensure is protected under your trademark. An example of a word mark versus a design mark could be the word Coca-Cola versus the font of Coca-Cola. Keep in mind that with a design mark, you must continue to use that design mark in the same style, format, or even color of the trademark application to maintain your trademark rights. And changing that design may require filing a new trademark application. In this instance, with all 3 of the skin trademarks in question, you'll notice that they are all word marks. Which means that they're claiming the broadest type of protection possible, and they are all expecting to have maximum flexibility in the way that they use their trademarks. Next, let's talk about the priority date. Trademarks are granted on a first-come, first-served basis. So if I file my trademark today and you file your trademark tomorrow, I get priority of registration over yours. And if our marks are similar enough to be compared against each other, yours will be compared against mine. However, mine will be compared against any marks that came before mine. I hope that makes sense. What this boils down to is that time is of the essence when filing for trademarks. In this case, the application for Skin by Harvey was filed January 21st, 2021. The application for Skin Plus by Beauty Concepts LLC was filed March 28, 2021, and the application for Skin by Kim Kardashian was filed March 30th, 2021. So each of those applications would be prioritized based on their filing date, and the earliest filing date gets priority over the others. That means that it is likely that Skin Plus and Skin by Kim are both going to be compared to Lori Harvey's Skin because she filed in January and they both filed in March. Next, let's talk about the strength of the mark. Now I have a video that fully explains how the U.S. Patent and Trademark Office measures the strength of trademarks. If you haven't already watched that video, I encourage you to check it out. But just know that the strength of a trademark is critical in obtaining trademark registration for a particular brand. The weakest type of all trademarks is a generic mark. This is a trademark that is common to the public. And in the past, I've used the example of the trademark timepieces to sell watches. These common or generic words generally do not qualify for trademark registration. Why? Because that would make those trademarks extremely hard to enforce. The general public has the right to use common or generic words to describe products and services that they might be selling. Offering trademark rights for generic terms would not only restrict the English language, but it also would restrict competition among businesses. The second type of trademark on the scale from weak to strong is a descriptive mark. Descriptive marks describe a product or some aspect of the product, such as an ingredient, a quality, a feature, a function, a purpose. For example, a trademark of cold and creamy for an ice cream brand would be a descriptive mark. That doesn't mean that a descriptive mark does not qualify for trademark protection. However, that protection, if granted, is severely limited. I think there could be a case for the term skin when identifying skincare products or cosmetics to be a descriptive mark. But I could also easily argue that it just barely misses that threshold of being just merely descriptive. Ultimately, it would be up to the trademark examiner to make that decision. The next strongest trademark is a suggestive mark. And a suggestive mark hints at or suggests certain attributes of a mark without actually describing the product or service. An example is Burger King, suggesting that it is the king of burgers. And while these types of marks are generally protectable, they may be subjected to much less extensive trademark protection. I think it is also appropriate to say that any trademark derived from the word skin that is identifying a skincare line or skincare products or cosmetics as its goods or services is suggesting that the goods are designed for the skin and therefore suggestive. So we can check off that while each of these three trademarks are common terms derived from the word skin, that they do qualify for some level of trademark protection even if it is limited. Last but not least, let's talk about the primary standard for measuring trademark infringement, which is a likelihood of confusion. So all of the previous factors that we've discussed are very relevant to the assessment of a likelihood of confusion. And I have another video that breaks down the likelihood of confusion in great detail if you're interested. So today I will merely skim through the factors that are most relevant to this conversation and related to these three trademarks. Remember, you can have a likelihood of confusion based on similarities in appearance, meaning, sound, feel, overall impression, trade channels, and the relatedness of goods and services. We've already discussed the strength of the mark, and there are clear similarities in appearance, sound, and the goods and services that each trademark identifies. So let's talk about the marketing channels used. Both Lori Harvey and Kim Kardashian are well-known celebrities with major followings and access to resources. So it is very likely that their brands may travel in the same channels, both through e-commerce, being sold online through various websites, and in brick-and-mortar retail stores. However, Skin Plus is an actual salon and spa in Brooklyn, New York. While they may market their goods and services through an online presence and in a brick-and-mortar retail store, i.e. their own local spa, it is far less likely that Skin Plus will receive the same level of marketing as Skin by Lori Harvey and Skin by Kim Kardashian. It is also far less likely that consumers of Skin Plus salon services would largely affect and impact consumers of the other two brands, which may be sold in retail department stores such as Macy's and Bloomingdale's. Now let's talk about the degree of care being used during a purchase of either one of these brands. If I were one of their trademark attorneys, and depending on the position that I was in, I would argue that the consumers of these skincare products are sophisticated purchasers. Basically, what that means is that the people who are buying these skincare products are not doing so on impulse. This is not an impulse buy. Impulse buy is when you go to Walmart and buy some facial wash. When you are going to a department store or an actual local spa or salon to purchase skincare products, you are doing your research and you are choosing that product based on a level of detail. Generally, those types of consumers are well informed on the brands that they choose. And they choose those brands based on their own individual values, whether it's based on their own social responsibility and the social responsibility of the brand, whether it's based on the ingredients used or how ingredients are tested, or whatever may resonate with that particular consumer. And again, with two brands being marketed by very well-known celebrities with millions of followers, the relevant consumers of these brands will be purchasing the brand, at least initially, based on the celebrity status of the owners. Last but not least, I want to discuss the likelihood of expansion into a particular market. This is particularly relevant with the Skin by Kim trademark application. Upon reviewing the USPTO trademark database, you can see that Skin by Kim has multiple applications for various goods, ranging from vanity mirrors to printed calendars to towels and washcloths. So there is a clear intention for expansion into a particular market, at least by Kim Kardashian. This could also become extremely important when comparing Skin Plus against Skin by Kim. Kim Kardashian could amend her trademark application to narrow her classes of goods and services so that Skin Plus and Skin by Kim do not even overlap. And that could be a winning move for getting her trademark registration approved. Let's do a quick check to see where each of these trademarks are in their process. As you can see, Skin by Lori Harvey has already received a notice of allowance, which means that she just needs to show the USPTO that she is using her trademark in commerce. And because her skincare line has already launched, she can easily prove that she's using her trademark in commerce. And her trademark will be approved. However, upon approval of her mark, she will need to enforce her trademark rights against Skin by Kim to ensure or to further prevent that trademark from being registered, at least for the skincare products and cosmetics. Next, we have Skin Plus versus Skin by Kim. And here you'll see that they are involved in a legal proceeding, and both marks have been suspended until the court, i.e., the Trademark Appeal Board, rules on the matter. As you can see, there is a lot of analysis that accompanies a trademark filing. It's not a matter of just completing the application, although if you have an extremely unique mark, that may be the case. The factors that I went over today are just a few of the metrics that goes into filing a successful trademark application and ultimately getting a trademark registration. So if you've ever wondered why a trademark attorney charges so much, it's because a good trademark attorney wants a successful trademark registration and knows what it takes to get it. I hope this video was helpful and gave you a little bit more insight into how trademarks are assessed against each other when there is a likelihood of confusion or the possibility of one. And let me know in the comments what your thoughts are on Skin versus Skin versus Skin Plus. I'd love to hear what you think. As always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I'll see you in the next video.